We're pleased to debate the Honourable Member for Nunavut.
Uqaqtittiji. I'm honored to speak as the NDP justice critic regarding Bill C-14, and I acknowledge that there's such a huge public concern about the bail system, and Canadians do want to feel safe. The NDP, having read through this bill, we do have concerns. There are real challenges of our bail system. Some examples include the high detention rate of those charged and awaiting trial. 1/3 of those charged are never convicted of anything. Jails are full and bursting. This bill does not address resources to provinces and territories who will have to bear the burden of this bill. While in detention, there is no access to supportive programming like drug and alcohol addiction programs or any other substance abuse programs. There's a severe lack of data about the number of people out on bail who are reoffending. And of course, we all know that there is an overrepresentation of Indigenous and marginalized communities in corrections. Conservatives like to talk about catch and release to stoke fears. Most of these are urban public disorder problems caused by poverty, drugs, and alcohol and mental health problems. Jurisdictions all over the world, including the United States, have a tough-on-crime approach to bail, which does not make communities safer. We see that all the time in media. Often these policies make communities less safe and increase recidivism. Regarding pre-trial detention, I do have some facts to share. Over the past 30 years, the rate of pre-trial detention in Canada has more than tripled. The rate is far higher in places like the United Kingdom, Australia, New Zealand, Ireland, and most Western European nations. The poor, the homeless, and those suffering from addiction or mental health issues are more likely to be denied bail and held in detention because for a few factors. They don't have phones, or they don't have access to stable housing and employment, which are necessary to meet requirements of bail. They lack friends and relatives who could serve as sureties. More than 60% of those being held in provincial correctional institutions are awaiting trial. Many detainees are never convicted of an offense as less than 60% of charges result, and less than 65% of charges result in convictions. Those in pre-trial detention have no access to any alcohol, drug, or mental health problems. Even short periods in detention lead to higher rates of future conflict with the law. More than 40% of those detained are held for longer than a month. Pre-trial detention often has serious impacts, which can lead to loss of housing, employment, and custody of children. For those who do get bail, failure to meet conditions set out for bail often lead to additional criminal charges. Too many of those lack the personal supports and resources necessary to meet those conditions. As I mentioned briefly, there is a serious lack of data and evidence-based information for reform, and that is what we're calling for. There are no jurisdictions in Canada that collects standardized data about numbers of people out on bail and what bail conditions were when offenses were recommitted while in bail. The Canadian Civil Liberties Association made a submission to the Just Committee and included recommendations about data collection. They cited the importance to ground amendments to the criminal code in data and evidence. The conduct regarding legislative reform, it must be done with adequate data that has been collected. Federal government must collaborate with provinces and territories and civil society to launch specific initiatives to collect and report standardized data about bail systems to inform legislative reforms. There must be improved conditions in provincial and territorial jails because the potential for poor conditions undermines objectives of preventing crime and ensuring rehabilitation. There is a lack of leadership from the federal government regarding data collection in the criminal justice system. Another concern is the overrepresentation of Indigenous peoples in the corrections system. Indigenous peoples are drastically overrepresented in the correctional system. This bill would establish a broad category of reverse onus bail provisions applying to many offenders. It would have a disproportionate effect on Indigenous, racialized, and marginalized Canadians. There are, of course, specific Nunavut concerns because of the lack of infrastructure and a traveling court system. Canadians' concerns about violent repeat offenders are real. New Democrats also are concerned, but we are concerned that rushing ahead with reforms without data, without considering impact on Indigenous and marginalized groups is a huge concern. These broad reforms without informed data or evidence is not the solution. New Democrats have a different approach to bail reform. There needs to be pragmatic and achievable solutions to keep communities safe. They need to address root causes of crime, and justice reform should be targeted, not broadly capture everyone. We need to provide better supervision for those on bail. Solutions on demand drug, alcohol, mental health treatment programs to end the revolving door of criminality. For these reasons, NDP believe in supporting and expanding community-based bail supervision programs. For example, the John Howard Society has run bail supervision and verification programs in partnership with the Ontario Attorney General since 2011. These programs now operate in 17 Ontario communities. The success rate of that program is over 90% in making sure bail conditions are observed and clients show up in court. Costs are $5 per day as opposed to $184 per day for detention in Ontario, and they have reduced the overall numbers in pre-trial detention. These programs ensure those on bail meet their conditions and have opportunities to be connected to alcohol, drug, and mental health treatment programs. The Canadian Civil Liberties Association agrees with the NDP that Canada must increase support for community corrections. There must be additional bail supervisors hired and implement alternate bail release and supervision programs and focus on offenders with mental health and addictions challenges. The NDP is cautious in our approach to this bill, and we will continue to consult with women's groups, with civil liberties groups, with Indigenous groups to ensure their voices are being heard. Uqaqtittiji.
Questions and comments? Question, commentaire, the Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. When I reflect in terms of the desire for my constituents, in terms of looking at bail reform, the Prime Minister made a commitment to bring in bail reform, and that's what we're debating today. I understand the comments that the NDP have put on the record. A very straightforward question. Does the member or does the NDP support the principles of Bill C-14 for bail reform?
The Honourable Member for Nunavut.
As I said, we are quite cautious in our approach. I think that I'm very concerned, especially for the reverse onus sections of this bill. We know that, for example, even the former ministers of justice, David Limedy, as well as what was his name? The other one, sorry. I'm so sorry to him. They didn't agree with reverse onus because they felt that it didn't make the public safety increase. So I am quite concerned about it. Uqaqtittiji.
Question et commentaire? All right.
Questions and comments. The Honourable Member from Ocadam. Thank you, Mr. Speaker. I thank my NDP colleague for her speech. She raised a very interesting point. She talked about the associated costs. The government's amendment to the criminal code, the federal government's amendment to the criminal code when it comes to marijuana, made it such that the federal government received taxes and kept it all for themselves. Meanwhile, the provinces had costs because they had to run the programs. In this matter, the government would change the criminal code, which is easy to do, but there will be costs for provinces who are already struggling. Would my colleague agree that the federal government should give provinces the necessary funds so that they can handle these changes?
Thank you so much for the important question, because I do agree, as I mentioned in my speech, that I'm quite concerned that it would be, if these amendments do go through, then it will leave the provinces and territories without the resources that they need to be able to make sure that the people that they have to take more care of, they won't be able to. I mentioned the very fact that Nunavut has 25 fly-in communities. It has a traveling court, and I don't know how they would manage the additional work that would be required to implement this bill.
Questions and comments? Question et commentaire? The Honourable Parliamentary Secretary, the Government House Leader.
Yes, I'm not 100% clear in regards to the NDP's position in terms of the passage of the legislation. Given the very nature of the support from many different stakeholders that are out there, would the member not agree that this is legislation at the very least should pass into committee?
The Honourable Member for Nunavut.
I do agree that it needs to reach committee so that there could be deeper consultations and conversations about this bill.
Questions and comments? Question et commentaire? Resuming, the Honourable Member for Oakville West.
Thank you, Mr. Speaker. I just have a very short comment. So the bill has a big support. There is a tremendous support from the provinces, territories, and lots of municipalities, as well as premiers, ministers from provinces, and mayors. So various police associations also show their support for this bill. So I would like to thank the Minister of Justice, Minister of Public Safety, our Secretary of State for Combating Crime, and their teams for working on this bill and spending the entire summer with us, going and seeing all law enforcement in our ridings. So I really want to thank everybody who put this bill together, and looking forward to pass it at the shortest time. Thank you.
The Honourable Member for Nunavut, a brief response.
I do hope that there are more consultations with Canadian Civil Liberties Association, with the BC Civil Liberties Associations, with Indigenous groups, with women's groups, because it's those groups that are not feeling heard with how this table was built, and I do hope that there will be more work to hear from those most marginalized communities.